So as I say, welcome again to this morning's session, Cross-Border Estate Planning in Scotland and France, and the challenges of navigating forced heirship. My name is Jessica Flowerdew. I'm a senior associate here at Brodie's, and I'm joined by Emilie Bensmihen, who's a solicitor at Buckles LLP. She's qualified in England and Wales as well as in France. I should mention I'm also a member of the Franco British Lawyers Society, the Scottish section, and I'd like to extend a very warm welcome to all FBLS members today. Next slide, please, Rachel. Today we are going to talk about the challenges of forced heirship in Scotland and France, one of the many things that we have in common. We're going to briefly cover the private international law rules in both jurisdictions that determine the law applicable to the succession of a person's estate, namely Brussels IV in France and the Scottish concept of domicile. We'll consider the impact of UK inheritance tax on Franco-Scottish estates before discussing Scottish legal rights. Emilie is then going to take us through forced heirship in France and the controversial new domestic law there, which might have an impact on foreigners with assets in France. We'll also consider what opportunities there might be for those that have interests in Scotland and France to plan for their succession. And I'm going to hand over now to Emilie, who's going to take us through Brussels IV.
Thank you, Jessica, for this introduction. So the starting point when planning an estate is to understand which law applies to the devolution of the assets, so we can actually organize things. In France, we refer to the European regulation on succession called Brussels IV, and I'm therefore going to give you a very quick overview on this regulation. So Brussels IV is dated 4th of July 2012, but it actually came into force on the 17th of August 2015, and it affects individuals whose deaths happened after that date. It has been ratified by 25 member states, basically all the member states at that time except the UK and Denmark. And it has completely changed the landscape of cross-border estates where member states are involved. The main changes are, first, it has unified the law applicable to an entire estate, where before we had many different connecting factors, and provided the default position that this unique law will be the law of habitual residence of the deceased at the time of death. But it has also provided now the possibility for the testator to choose the law of his nationality to apply to his entire estate. So I have listed a few articles that are the essence of the European regulation, and which are really important for our topic today. So the first article is Article 21.1, which provides the default position and state that unless otherwise provided for in this regulation, the law applicable to the succession as a whole shall be the law of the state in which the deceased had his habitual residence at the time of death. And we also have Article 20, which is really important for us as planning with the UK, especially, because it states that the regulation will apply even if the law of habitual residence is not the law of a member state party to this regulation. The thing is that we do not have any definition on habitual residence. So in the regulation, there is no specific definition, but we have guidances in the recitals. We also have case laws now. And we understand that it is the center of interest where an individual spends their day life and have an intention of staying there. There is an article, a very important article missing on that slide, which is Article 22, which provides the possibility for a person to choose the law of his nationality to govern his succession as a whole. And this is a very important tool for us. Now we're going to look at the renvoi. So this is also important for planning an estate, to understand this mechanism and how Brussels IV is dealing with it. So as a reminder, renvoi is the passing of responsibility from one jurisdiction to another. And we're going to see in a few minutes with Jessica that the UK have different private international rules, and in some cases will not accept to deal, for example, with a property located in France. And in that case, we have to refer to this Article 34 of Brussels IV, which states that the application of the law of any third state specified by this regulation shall mean the application of the rules of law in force in that state, including the private international law insofar as those rules make a renvoi. So what it means is that basically by application of this article, in our example, France will consider the UK to be a third state, so renvoi to French law will have to be accepted if the law of the deceased habitual residence is Scottish law, for instance. However, this Article 34 goes on to specify that there are some cases where there should be no renvoi included. And that's the case when the deceased had chosen the law of his nationality to apply to his worldwide assets. So basically, as a summary, when we apply the law of habitual residence, and it's a law that renvoie to French law, then French law applies. But if we apply the law of the chosen law of one's nationality, then renvoi will not take place, and the French notaire will have to apply Scottish law, for instance. Now I will let Jessica explain to you how international private law and inheritance rules work in Scotland, before I come back to discuss the French rules and what to consider when planning an estate between the two jurisdictions.
Thanks for that, Emily. So Scottish private international law makes the distinction between the law applicable to the testator's heritable and movable property. The law of the country in which the heritable property is located will apply to its succession, whereas the law of the deceased domicile applies to their movable assets wherever they are situated. Scotland, as Emily's already told us, is not and has never been a signatory to Brussels IV, but Scottish nationals might still be affected by its terms. Scots with assets in France should take advice about the impact of Brussels IV on their succession. In some cases, it might be advisable to make a choice of law election under Article 22 in favour of Scotland, but we can discuss that in more detail towards the end of the presentation. Each case will turn on its own merits, and it's really important to take bespoke and specialist advice before you make a choice of law election. Excuse me. There are various practical differences that we should remain aware of in cross-border cases with France. And this is important because if the law applicable is the law of Scotland, then movable assets will succeed in accordance with Scots law. again, wherever those are situated. So unlike in France, heirs do not inherit directly from the deceased. Instead, the estate will be administered by executors or personal representatives who take ownership of all of the assets in the estate and then distribute those in terms of the will or in terms of the law if the deceased dies without a will. The executor's authority to do that is obtained from the Sheriff Court in the form of a grant of confirmation. The estate is also formally administered, so it's investigated by the executors. The executors gather the assets, they pay debts and taxes, and then they distribute the assets in accordance, as I say, with the deceased will, subject, of course, to Scottish forced heirship rules, or in accordance with the law if the deceased died without a will. And we're going to talk a bit now about the concept of domicile, because that that's the concept that will determine the law applicable. So the concept of domicile in Scotland is subjective. It deals with intentions and not necessarily with physical presence. It is the law that will determine the succession to the estate of a deceased person and the tax regime applicable on their death. So it is absolutely crucial to determine where a person is domiciled. There are four main types of domicile, and I've listed them at the bottom there: a domicile of origin, a domicile of choice, a domicile of dependence, and we also talk about deemed domiciled for inheritance tax purposes. I'll look briefly at each of these. So the domicile of origin is the first one. Everyone will acquire a domicile at birth, known as their domicile of origin. That's generally based on the father's domicile if the parents were married at the date of birth, or else it's based on the mother's domicile. It's possible for a person to have a domicile of origin in a country with which they themselves have very little connection because they acquire the domicile of their parents. You never lose your domicile of origin, but it can be superseded by a domicile of choice or a domicile of dependence in another country. We'll go on now to talk about how that might happen. So a person over the age of 16 can acquire a new domicile in a new country if they're physically present there and they have a fixed and settled intention to remain there permanently. If a person's domicile of choice is abandoned because they move somewhere new, then their domicile of origin will revive automatically to plug that gap until such time as they have developed a new fixed and settled intention to acquire another domicile of choice in another jurisdiction. Domicile of dependence now only applies to children under the age of 16. Children under the age of 16 share the domicile of the person on whom they are dependent, the father if the parents are married at the date of birth, or the mother if the parents are not married at the date of birth, or the married father is dead. If the person on whom the child is dependent changes their domicile and acquires a new domicile, the child's domicile will also change. In accordance with the Inheritance Tax Act, a person is deemed domicile in the UK for IHT purposes if they meet certain criteria. I'm not proposing to go into this in too much detail. Most notably, they will be deemed domicile in the UK if they were UK resident for income tax purposes for 15 of the 20 years immediately preceding the relevant tax year, and for at least one of the last 4 years ending with the relevant year. Non-domiciled spouses can elect to be deemed domiciled in the UK under the spousal election rule. But again, it's really important to take specialist advice before you make a domicile election under the spousal election rule, because the implications of doing that are significant. And we'll talk a bit about why they're so significant in the next slides when we discuss UK inheritance tax. Individuals who die domiciled in UK will pay UK inheritance tax on their worldwide assets, generally at a rate of 40% on the balance of those assets above the nil rate band, which is currently set at £325,000, and that will include the value of gifts made in the 7 years prior to the date of death. The deceased estate may also qualify for the residence nil rate band, which is currently set at £175,000, provided certain conditions are met. Non-UK domiciled individuals will pay UK inheritance tax only on their UK assets. They may also be eligible for the residence nil rate band as well as the nil rate band. Again, the residence nil rate band will only be available provided certain conditions are met. And we're going to go on now to talk about the spouse exemption, which is really important and which affects spouses with different domiciles in different ways. Transfers between UK domiciled spouses on death are exempt from inheritance tax. Transfers between non-UK domiciled spouse to a UK domiciled spouse are exempt from inheritance tax, but transfers between a UK domiciled spouse to a non-UK domiciled spouse are capped. They're capped at 325,000. These spouses will also have an additional nil band allowance of which is currently 325,000. So it means that any transfers above 650,000 are liable to inheritance tax. And again, as I mentioned before, it is possible for a non-UK domiciled person with a UK domiciled spouse to elect to be treated as UK domiciled for inheritance tax purposes, either during lifetime or on death. But it's crucial to take professional advice before you do that, because if you are UK domiciled, then you will pay UK inheritance tax on your assets wherever they are situated and not just on your UK assets. Those with assets in Scotland and in France might find themselves having to pay inheritance tax in both countries. In the context of France, we can see how this arises because France taxes beneficiaries, whereas the UK applies IHT to the deceased estate. We do have a double taxation agreement between the UK and France that operates to mitigate exposure to double taxation of the same asset. But it is complicated, and recovering tax in that way can be really time consuming and complex. So again, really important to get that advice if that is something that you're looking to do. I'm going to turn now to talk about the issue at hand, so Scottish forced heirship, and we call our rules of forced heirship legal rights. Legal rights in Scotland apply to the net worldwide movable assets, so they would include assets that are movable in France, and they apply to the estates of those who die domiciled in Scotland. They apply irrespective of whether a person leaves a will and irrespective of the terms of that will. So it's not possible in Scotland to prepare a will and defeat legal rights in that way. Where the deceased is survived by a spouse and children, the spouse will receive 1/3 of the net movable assets and the children will receive 1/3 of the net movable assets. And the third that goes to the children is divided amongst all the children. The remaining movable assets are then distributed in terms of the deceased's will. So the deceased retains that testamentary freedom over that 1/3 of the movable assets. Where the deceased leaves only children or only a spouse, the entitlement of the surviving children or the surviving spouse will increase to 1/2 of the net movable estate. So when talking about legal rights, it's important to highlight that these are not rights of succession. They are a debt on the estate and the executors must pay that before they distribute the estate or have the legal rights discharged. The impact of legal rights is huge because movable assets will include, for example, interests in partnerships, and they can include land and buildings that are owned by the partnership. So you can imagine in farming families, legal rights are a major issue. Legal rights claimants have 20 years from the date of death to claim their entitlement, and if the executors fail to deal with legal rights, they can find themselves personally liable to pay them. It's really important in this context when we're talking about cross-border estates for people to be aware of the fact that Scottish domiciled individuals cannot defeat their legal rights if they die with movable assets. So if you are Scottish domiciled, legal rights will apply to the succession of your estate. Those with interest in France will also have to be mindful of forced heirship rules in France and how those might affect them there. And Emilie is going to now take us through the rules in France and the impact that those have on cross-border estates.
Thank you. So yes, before explaining French inheritance rules, I wanted to point out a few distinctions with the Scottish system, because I think it's really important to understand those distinctions before when we have to consider the two systems together. So first of all, Jessica already mentioned it, but this is really important. Like in France, heirs are directly vested. There is no transfer. The transfer of ownership applies directly from the deceased to the beneficiaries. There is no transition through an estate as it is the case in the UK. And there is no concept of executors, the way we understand it in a common law system. So the notaire is a professional who transferred the ownership and is also the professional who's going to administer an estate. We do not appoint executor in wills on a common basis. This is not something frequent. And they are not homologated by the court on an African basis either. The other important distinction is that the freedom of testamentary disposition is restricted to the disposable portion of the estate. And we will see that in a minute, how reserved heirship works. But the purpose is to protect the children in the first place. And we do not distinguish between movable and immovable assets, but rather we rather reason in terms of shares of the entire estate. So now moving on to French inheritance law. According to French law, a person's estate is divided between two parts, the legal reserve and the disposable portion. And as you can, so basically the legal reserve is the portion of the estate that must, by law, be left to specific beneficiaries. And this is irrespective of whether the person had made a will or not. And then we have the disposable portion, which, as it suggests, is the portion that a person can dispose freely of. And as you can see on this table, the size of the legal reserve and of the disposable portion vary depending on the number of children the deceased had. And now I'm going to quickly look at the right of the surviving spouse. So the surviving spouse, what the surviving spouse receives from the estate is depends on whether there were children only from that spouse or from other relationship. And you can see the options on this table. However, so if the deceased had made a will in favor of the surviving spouse, then the surviving spouse options would be the same whether the deceased had children from another relationship or not. And the surviving spouse is protected heir only in the absence of children. So basically, it is possible to, if there are children, it is possible to disinherit the surviving spouse. But if there are no children, the surviving spouse has to receive a minimum of a quarter of the deceased estate. So yes, Jessica.
Yeah, so thanks, Emilie. So we're now going to talk about what estate planning opportunities there are for Scottish people with assets in France. Scottish nationals with assets in France might choose to make a choice of law election in favour of Scotland in order to avoid French forced heirship rules. And the incentive here is that legal rights will apply only to movable assets, whereas the reserved portion in France applies to both heritable and movable property. But Emilie is going to go on to talk about the controversial French DPC law that might have an impact, and it remains to be seen what that impact will be. So whether the French will consider that legal rights sufficiently protect reserved heirs is a question that we don't have the answer to yet. And Emilie is going to tell us a lot more about that in a couple of minutes. One point to note is that a national participating EU member state who dies domiciled in Scotland can't escape Scottish legal rights by making a choice of law election, as we've already said. So legal rights for Scottish domiciled people are not possible to defeat in that way. They will apply regardless. And I'll pass over now back to Emilie, who is going to take us through various estate planning considerations in France, and is going to talk us through the DPC.
Yes, so before jumping in the controversial topic of the Droit de Prelevement Compensatoire, I'd like to draw your attention on another important thing to consider when planning an estate with a French element. And this thing is taxation, basically. Because taxation is specifically excluded from Brussels 4. So we need to look at as Jessica mentioned earlier, there is a double tax treaty between France and the UK, and we need to look at this double tax treaty to see which assets are going to be taxed in France, and how this is going to work. And if there are assets taxed in France, we need to keep in mind that the French system is really different. And again, we already mentioned it, the beneficiaries are directly vested, but they are also directly liable for the share they received in the estate. So the French tax system, you're going to see on the slides now, the system encourages devolution down the bloodline, and the children will receive like a tax-free allowance at the moment of 100,000 euros per parent. And after that, they're going to have the most favorable rates compared to non-related, for example, people who are going to be taxed at 60% with a very small tax-free allowance. So basically, when planning to distribute an estate differently, like not to children, you'll have to consider that they may have inheritance tax implication. Jessica already mentioned it earlier. There is a double tax treaty between France and the UK, and this double tax treaty provides tiebreaker rules. But it also provides what to do when there is a double tax. For example, when a French property is going to be taxed under French law, there will be a credit in the UK for the inheritance tax paid in France. because as Jessica mentioned, if the deceased was domiciled in Scotland, for example, he will be subject, like he will have to declare his worldwide assets in Scotland and be taxed on it. So now, yes, now I'm finally going to talk about the Droit de Prelevement Compensatoire. So we do not have a translation for it. I think it's a very French concept. So we are calling it DPC. It is the result of a controversial law the reason you will understand in a minute. This law came into force in August 2021, and it applies to the estate of those who died on or after the 1st of November 2021. And its outcome is basically to reintroduce the principle of forced heirship in estates dealt with under a foreign law, which does not provide an equivalent protection for children. And it gives the possibility for those children to claim compensation of their rights. So two conditions needs to be satisfied for the DPC to apply. The first one is if at the time of death, either the deceased or at least one of his or her children is habitually resident in a European member state, or is a national of a European member state. And the second one is if the foreign law applicable to the estate has no forced heirship mechanism to protect children. So if both conditions are satisfied and the foreign will doesn't respect the children's French forced heirship rights, each child can claim compensation against, but limited to their deceased parents' assets situated in France, so that their forced heirship rights are fulfilled. So now let's see if legal rights, Scottish legal rights, could be an obstacle to the DPC. The problem, the main issue with the DPC and the law of 2021 is that there is absolutely no definition of what the mechanism of forced heirship is. So it is actually difficult to find what is equivalent to it because we have no specific definition. We know that the purpose is to protect children. This is clearly stated. And it seems that there is a common incentive that we should make a strict interpretation of what's forced heirship. So what to think, since Scottish legal rights relates only to movable assets? Is it a case-to-case scenario depending on what type of assets are in France? Actually, this is really an open question, and I'm sorry, I'm not going to be very helpful here because I'm not sure of the answer. And actually, if you have any comments on this or any ideas, that would be very welcome. But what to expect if it was applying, if the DPC was actually if actually legal rights were not an obstacle to DPC, then remember, it's only a possibility. This is not automatic, but basically we'll have to inform the protected heirs that they have this possibility to have a claim to get a compensation. This is limited to the French assets only. And so it will, it's going to, it means that we will have to find the heirs. And in any case, because also we will need to ensure if they are European member resident or national, and to ensure if they would have a possibility to claim a compensation. So that's going to be a lot of complication for the notaires and for the executors of foreign wills, just in finding the heirs. But also we have absolutely no idea of how it's going to be taxed, how inheritance tax is going to apply to this compensation if there is any claim. At the moment, we have no case law yet, so I'm not aware of any case law. I know a lot of practitioners are waiting to bring the DPC to the European Court of Justice, because of course it seems to be contrary to the principle of unity of law and election of law of nationality provided by Brussels IV. But unfortunately, until then, I think it will have to be a case-to-case scenario, and the notaires will have to be very careful when dealing with a French estate, and we will have to also be very cautious in when we are doing estate planning, of course, specifically with Scotland, because it seems that in some cases, legal rights may not necessarily cover the protection required. So I think that's it for from us now, and it's time for questions. So please send your questions through the Q&A chat, and we will be very happy to answer.
So I think we've got some questions already, Emilie. So we've got a question here. Some advisors in the past have suggested separate wills for those with one estate in the UK and the other in an EU state. Is this feasible or to be recommended? The objective is that administration is simpler dealing with respective notaries or lawyers. Do you want to go first, Emilie? Or
yes. So this is a good question, but unfortunately there is no right answer. Like, there is no one answer. In some cases, yes, it is better to have separate wills. In some other cases, it's better to have one will only. It really depends on what we want to achieve, what the clients want to achieve, and yes, specific circumstances. Also, which law will apply to their French assets or to the European assets, where they are residents. I mean, there are many things to consider, and there is unfortunately no answer no, not one answer, but it's a case to case. Yeah, depending on the situation, I think.
Yeah, I would totally agree with that. And Emily and I worked on a case recently where we decided that one will was the better approach, but it will just depend. Each case will depend on its own circumstances, and as Emily says, what you're trying to achieve. We've got another question here. Would Scotland be deemed to be an EU state? I think the answer to that is that Scotland has never been a member, has never been a signatory to Brussels IV, so has always been treated as a third party state. Although that's now pretty conclusive post Brexit. I don't know if Emily, you have something you'd like to add here.
I mean, I don't think it will be considered a European member state for the purpose of Brussels IV, unfortunately. But maybe one day, yes.
And I think we've got another question here. Question arises sometimes with Scots long resident in England, say London, and then move to retire in France. Choice of English or Scottish law possible?
So that's again, that's really depends on what the client wants to achieve. It's not because UK residents move to France that they necessarily need to make a choice of English or Scottish law. It depends what they want to achieve again. This other thing that needs to be considered in when you want to make a choice, an election of law of one's nationality, is that at the moment, it seems, at least in France, that to administer the estate under Scottish or English law, we will need a grant of probate. And the problem with that is that if there is no assets left in England or in Scotland, then that would be difficult to obtain. So that's another thing to consider when you make a choice of election, is where are the assets located. And yes, again, like every situation, every person is different. Every person is trying to achieve things differently, and that's why, like, people think that it's, they are in a simple situation because they just move, but they want to keep their they want to keep their domicile in another jurisdiction, or I don't know, like it's not that simple, and every case needs to be studied carefully.
Yeah. And I think the other thing about this question is that, as we know, you have complete testamentary freedom in England. So if you were making a choice of law election in favour of England, then the DPC might just bite anyway. So definitely one to consider. We have another query here. When you mean separate wills, do you mean one for French assets and one for Scottish assets? What if one spouse is French? So yes, I think that is generally what we mean. Usually, you would have a will governing worldwide assets, but excluding assets in the other jurisdictions. So, for example, if you were preparing a Scottish and a French will. You would prepare a Scottish will covering the worldwide assets, excluding the assets in France, and you would prepare a French will that sat alongside that dealt only with the French assets. We've got a couple more questions here that we'll try to get through. So here, if Scottish legal rights are potentially not protective enough for DPC purposes, is it clear that English discretionary rules are definitely not equivalent? Emilie, do you have any experience of this? How are notaires dealing with English choice of law elections in France?
Yes, so I think that it's not that definitely and that clear, but it seems like yes, English discretionary rules. Yes, it seems that there is no protection under English law as far as DPC is concerned. But again, we don't have any case law, so it's very difficult to give a definitive answer to that. But it seems like people, like practitioners, seem to think that yes, there would be DPC for if English law were to apply.
Great. So I think we have one more question that we have time for just now. So here we have, it could be one will for a UK state and no will for another EU state, applying that state's common rules of inheritance. I'm not sure I fully understand that. Emilie, do you have you got the question there?
UK state and no will for other European state applying the state's common rules of inheritance. I think I understand what it means, like basically one will for the UK and just leave it to French regulation, or just not mentioning what happens in a European member state. Well, that's not really recommended, because in any case it's always recommended to just ensure that we have a clear guidances on which law applies actually. That would definitely help the different executors or notaires or whoever is going to be involved to understand what they have to do. So usually when there is one will, we want it to cover either all the assets worldwide, or we recommend to, if it's restricted to the UK, we recommend to ensure that there is something in France. I mean, I cannot talk about other European states, I'm sorry, but in France, at least, we would recommend something to be put in place so we ensure that it is clear if it's French law or another law applying in France as well. Hope I answered this question.
Thanks, Emilie. So I think that that brings us to the end of our presentation. Thank you very much for joining us today, and I hope this has been helpful.